Hello, everybody. Welcome to part 3 of the video series on the concept of beneficial ownership. I've made 3-part series on the concept as well as certain international case laws on beneficial ownership. So, essentially, in the context of international taxation, what is meant by the term beneficial owner. So, beneficial owner is essentially a person who has the full privilege to directly benefit from passive income streams such as dividend interest and royalties. It is essentially a concept which has been there to safeguard or to prevent abuse of DTAs by undertaking treaty shopping, and it primarily applies to passive incomes like dividend interest and royalties. You may refer to part 1 of this series of videos for a more detailed conceptual understanding of the concept of beneficial ownership. So today I'll be discussing 3 case laws. Let us take the first case law. The first case law that I have picked up is in the case of Prevost Car Inc. This is a case law of the Canadian Tax Court. So in this particular case law, it is in respect of the dividend income. The Tax Court of Canada took the view that where a company had discretion as to the application of the dividends received, then it was considered the beneficial owner. So this case, it concerned a Dutch holding company, Prevost Holding, which was a joint venture between UK and Swedish shareholders. Prevost Holding was incorporated in the Netherlands but had no physical office or employees there. The company held all of the shares of its subsidiary, a Canadian company, Prevost Car. Over 6 years, Prevost Car paid 12 dividends to Prevost Holding. Now, the principal issue was whether, for the purposes of the Canadian Dutch Treaty, Prevost Holding was the beneficial owner of dividends it had received and which it subsequently passed on to its own shareholders. Now, the Canadian court held that Prevost Holding was, in fact, the beneficial owner of the dividends. There were a few reasons which were listed for the decision, which was one of the important reasons which was mentioned there was that Prevost Holding had discretion as to the application of the dividends, since it was not legally bound to distribute them to its shareholders as soon as they were received. So if you remember, we had discussed in the previous video in the case of Indofoods. In that particular case, the interest income was received and back to back it was transferred. And this company did not have any discretion as to using that interest income, etc. And on some occasions, it was even directly paid. However, in the case of Prevost Holding, that was the big differentiating factor. So Prevost Holding did have discretion as to the application of the dividends. So Prevost Holding was said to have both received the dividend for its own use and assumed both the risk and control of the dividends received from Prevost Cars. The court noted that in order to regard the shareholders of Prevost Holding as the beneficial owners of the dividends, there would need to be absolutely no discretion resting with that holding company as to the use or application of the dividend received. However, in this case, it was up to the directors of Prevost Holding to declare a dividend for which shareholder approval was also required. So, in this particular case, it was held that Prevost Holding is the beneficial owner of the dividend. Now, let us discuss another case law in the case of Velcro Canada Inc. versus the Queen, this is again a Canadian court decision. This particular case law, the Canadian courts, they applied the Prevost Car ruling in a royalty context. This was decided by the Tax Court of Canada in the taxpayer's favor. So this particular case, it involved royalty payments made by a Canadian company to a Dutch intermediate company in respect of a license of IP, intellectual property, ultimately held by a group company in the Netherlands and Thailand. The payments from the Canadian group company to the Dutch intermediate company were made under the provisions of the Dutch-Canada Treaty. The Canadian tax authorities questioned whether the Dutch company was the beneficial owner of such royalties. The tax court based its approach on the concept of beneficial ownership that had been used even in the case of Prevost cars. With respect to the possession and use, it was noted in the Velcro ruling case that the Dutch company did not simply collect and immediately forward 90% share of the royalties collected from Velcro Canada. Rather, the funds were mingled with other funds from other sources and sometimes converted into a different currency as well. So, any amounts that the Dutch company held in its accounts earned interest income for its benefit and were used to pay its expenses as well. In light of these facts, it was clear to the tax court that the Dutch company had both possession as well as use of the Velcro Canada royalties. In addition, the court noted that company had assumed some conventional commercial risks with respect to the royalties. The court therefore concluded that the Dutch company also had control over the royalties, and so the test of beneficial ownership had been met. So even in this case, it was held that Velcro was the beneficial owner of the royalties. Now, another case that I've picked up is of the Swiss Supreme Court in the case of A. Saal versus Federal Tax Administration. In this particular case, the Swiss Federal Supreme Court has concluded that in various forms of structured finance arrangements, where the recipient of the dividend or interest was required to make a payment on to a person in a third country, the immediate recipient was not the beneficial owner and so not entitled to relief under a treaty. The facts are that a UK resident company, D Limited, entered into a stock lending transaction with a related company in Luxembourg, ASA. Under the arrangements, the stock borrower provided substantial sums by way of collateral for the loans, and the stock lender earned significant amounts of interest from that collateral. For some of the stock lending, the stock borrower received a dividend. It was obligated to make a compensatory payment, a manufactured dividend, to the stock lender. Actual dividends were paid by various Swiss companies and were subject to the Swiss withholding tax under domestic law. The Federal Supreme Court upheld the finding that the Luxembourg company was obligated to make a compensating payment to the stock lender in the UK back to back and hence was not the beneficial owner. So this was a case which was slightly different from the previous two cases. And in this, it was held that ASAL was not the beneficial owner. Now, coming to certain common points or main points on the concept of beneficial owner. So essentially, the concept says that the beneficial owner is the person who actually owns that passive income, which can be either dividend, interest, or royalty. And he is not merely a legal shareholder who's just interposed to take some tax benefits or tax advantages. So the main points which are coming out of all the case laws and all the guidelines which are there eh, are listed on the slide. So first is that assumed both the risk and control of the dividends. Then the beneficial owner has the discretion as to the application of the dividend, interest, or royalty. He did not simply collect and immediately forward. So there's no back to back transaction. Uh, Otherwise, he will not be considered as a beneficial owner. The income that the beneficial owner is receiving is for its own benefit. He has also assumed certain conventional commercial risks with respect to the payments of receipt. So these are some points which kind of act as the test for determining whether it is the beneficial owner or not. Thank you so much for listening to this video. I hope it was useful. If you have any comments or if you have any questions, please do feel to reach out to me by way of an email or by way of a comment to this video. Thank you so much for listening. See you soon. Bye-bye.